Hello. Hi. Welcome to You and Your Right, brought to you by Fortress Solace. Every Monday from 7 p.m. to 8 p.m., we come your way with topical issues that might affect you. This evening, we're going to discuss an issue that probably you don't even want to talk about it because it is something that when we try to discuss, people get very agitated. But whether we like it or not, it is something that will happen. It's inevitable. That is your hard-earned wealth that you've got. It might be just simple as maybe a watch that you've acquired. It might be even your spectacles that you've bought. Might be a designer one. When you are no more, whom do you want that property to be bequeathed to? We don't want to talk about it, but it will be very, very good that you prepare yourself and make sure that that property, whoever you want that property to go to, should get it, not the law deciding that this individual gets A or B, whereby you worked hard for it. It might even be family issues, it might even be relationship that you are not there, but that individual who didn't struggle with you to obtain that particular asset will step in just because of the law and they will claim it. I don't think you would want that. And I don't think your loved ones, the ones that you struggle with, would appreciate the fact that it has happened to you. So, why should you consider making a will? Is it time? When should you do it? Is it when you are young? Is it when you are old? I will not talk long. But it's all going to be an education for you, as we always do it on You and Your Rights, brought to you by Fortress Solicitors. We just educate you, we just make you aware of things that probably you've not thought about. Seek legal advice as usual after this program, but it's just for educational purposes. We would urge you to share this video to other people because you and I, as we know, we will not live long on this earth. At one point in time, we will depart. Whom do you want that property to be bequeathed to? This is just an introduction. As we always do, we delve into the issue and we encourage you to share it to other people. And we thank all those who joined us last week. We had so many calls from people who watched last week video, and it's all because you shared the stream to other people to enjoy. I'm going to go back in a short while. Prepare yourself, an opportunity for you to be able to share the video to other people so that they will also benefit from it. You are watching You and Your Right, and it's brought to you by Fortress Solicitors. We're going to be right back. Hi, welcome back. You are watching You and You're Right. Thanks for joining us again in this studio this evening, wherever you're watching us from. I have our guests who will introduce himself shortly. Then we will go straight into the topic for this evening or any time that you are watching us.
All right. My name is Daniel Coy, and I work with Football Solicitors. So, if you're joining us for the very first time, I deal in immigration, I deal in wills and probates, civil litigation, family issues. And as we always say on this program, as much as we try to talk about immigration issues a lot because there's a lot of developments going on, it's important for us to share other important areas that we believe will benefit from some of our viewers and our listeners. And one of the most important areas that we think we need to talk about more as a community, as a people in the UK, is the need for people to make wills and why you have to make the wills, the advantages, some of the things that not doing it can cause, and all that. So, for today's program, this is what we are talking about. If you're joining me for the very first time, you don't know who I am. I'm a solicitor. I've been practicing for over 10 years in this area. Our law firm is based in North London, close to Wood Green Station, Haringey, Hornsey Station, and then it's also close to Tempaclin Station. We offer free legal advice, so we don't charge for any legal advice. So after we've done this program, if you have any questions and you want to get in touch, feel free to call us during our working hours, which is Monday 9:30 to 5:30. The important thing that I want people to take away from this program is this cannot replace a legal advisor you may get. This is for educational purposes only. So if you need to take a step, you want to do something, make sure you have spoken to a professional who will be able to advise you on the nitty gritties, what may be in your situation, because we are just talking about general situations at most times. Lawyer PK, as you said, today's program is an interesting one, even though most times people don't like talking about it, but it's important we do, especially in our community. We find it to be one of the things that people rarely want to do or to talk about for cultural reasons, for beliefs or whatever it is. But it's key that we get this thing sorted, or we get this thing talked about, the need for it, what it can do, what if you don't do it, it can cause. Even if you're doing it, we have to go to the right places for it to be done. The necessary questions need to be asked. So I think today is a packed one. We have a number of very good reasons why people might have to consider making a will. You've worked hard, and for me to as an introduction, it's very, very important for people to understand that as a living person, you have worked very hard for any assets that you may have. People sometimes feel they might not have any assets, so there's no need to prepare when they are not here, or if they make a will, then it means they are leaving soon. It doesn't work like that, but it's very, very, very important that we get this thing done and we talk about it as well. You've worked hard for your assets. Why do you have to leave it to chance? Why do you have to leave it for somebody to make a decision as to who your assets may go to? Why do you have to leave it that you may end up paying more tax than you are supposed to? What we normally call death tax or inheritance tax. After you've worked and you've paid so much tax whilst you're alive, you don't want to pass away and then you half of or more, almost half of your assets goes into taxes again, or things like that. And it is not even just that, the fact that sometimes after people have left, there is a family dispute on little things as who keeps the property, who lives there, who looks after the children who have been left behind, things like that. And that is the key question. And for people who originally migrated from one country to another, who moved from different countries to the UK. It's even important we listen to this because people might have assets abroad and they'll be thinking that, well, I live in UK at the moment, all my assets are abroad. Why do I need a will and all that? We will be discussing all this today. So it's important everybody tune in. And if you have questions, please feel free to leave a comment on the Facebook page. Feel free, whatever you've got, just add it, and we will more than happy to answer your questions. So we are going to answer questions today, and we'll be looking at it as much as we go along. So any questions you have, please leave it there. Please feel free to share with a friend, share to your groups or your any page that you want to do that, and then get in touch if after this program you want to speak to us afterwards. PK. So I think I've introduced us
Yeah.
properly into the topic. And if you may start with us, give us a few, maybe one or two reasons why it is important, it's imperative that everybody consider having a will. Why do we need to do that? Give us two key reasons, and I'll also follow it up with a few more reasons.
Okay. As we introducing this program, we said that you've worked tirelessly to acquire something that is dear to you. And obviously, inevitably, everyone would obviously die one day. Do you want that asset or do you want that particular legacy that you've left behind to go to someone specific to your heart? Or do you want the law to decide for you where that property is? That is one of the key reasons why each and everyone needs to get a written document to make sure that you name people who would get a particular asset or a particular gift that you acquired whilst you were living. So that is one aspect that people need to be aware of, and it's very, very important. Unless whatever you've acquired, you don't cherish it, and you think that if the laws are going to say that A is supposed to get it, B is supposed to get it, don't care. If that is what you think, then it is fine. However, if that is not what you think, unfortunately, if you don't have that document that we are going to talk about now, that we term it as a will, the law will step in and distribute your property for you. So first of all, it helps you to tell what who gets what. Secondly, it might also be very good for you to make sure that other people get specific assets or specific estates that you've got a particular point of time in their lives, whereby we'll be talking about trusts a little bit in this program, but obviously trust is another big area when it comes to wills. There are other people that might not benefit from your estate at a particular point in time of their lives. However, because you didn't have that trust or you didn't have that document to protect them being beneficiaries, they will find themselves holding on to that particular property and they might even misuse it. Meanwhile, you didn't even want that to happen to those individuals. Lastly, would you want anyone to share your property for you whilst you are not there, or you would want a specific person that you trust most to assist in distributing your property. All these things, if you think about it and it's something that you want to have a control over, although you are there, then this is what it's all about. This is the program that you need to listen to. This is the advice. Sorry, this is a topic that you need to understand very well because within this particular program or in this particular program, all these things are going to be explained to you so that you will have total control of your estate, total control of your asset when you are no more. But then if you would want to ask some of the advantages that you would get if you decide to adhere to this program and do something about, obviously, what you've left behind.
Yes, thank you very much, Leah PK. One of the things that I need to emphasize on is the need to have a will done if you have a child or you have children, because you want to ensure that your children are provided for financially when you are not around. And with a will, you can make plans and provide for their future financially. For example, you may wish to consider setting up a trust for your children so you can control when your children receive the funds and what it gets used for. It's very, very important. This is what high net worth individuals will normally do to protect their family wealth. But it's not simply available for people who are high net worth. It's also available to anybody at all. Sometimes you want to ensure that whatever you are leaving to your children goes to them at the right age, because probably you don't want a situation where they will just take the funds and somebody else will, because they are minors or they are children, they might just misuse it. They might not use it for something that they need to use it for. Maybe you want to leave something for them to use it for their university education, or you want them to use it to start a business, to start a family. You want them to use that money for something specific. This is what you ought to do, and this is something that you may have to consider seriously. As Lawyer Pique said, you may need to deal or get a trust down, which may be different from a will. But of course, today's program is not to discuss about trust, but trust issues are something that is very, 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 very important as well, because this may allow you to save on income inheritance tax, as we talked about. So if you put your assets in a trust, it may not be covered, or it might not come under the inheritance tax bill, depending on how much value that you may have in your estate when you are no more. One of the reasons why a lot of people try not to do well is because of the thought that they might not have any assets, or the assets that they have may not be enough. So why the need for a will to be done? But what people don't realize that sometimes whilst you are alive, you may not be worth anything, but once you're gone, you are worth something, because you might have an pension. You might have employment benefits that once you've passed away, they might want to pay to your estate. You might have a life insurance somewhere that comes with your bank account or something. So it's very, very, very important that no matter who you are, what you do, you still have to consider making this, so that whatever assets you are leaving behind, you can safeguard it for the person that you want to safeguard it for. And especially so as you will not want to, after working 30 years, 20 years, 50 years, all your life, paying income tax, VAT, whatever tax you can think about, paying all that, for only for you to realize that after you've passed away, you might end up paying about 40% in inheritance tax. So if you have left a lot money behind for your children, or a property behind for your children, you may realize that because of the amount of tax that they ought to pay, they cannot afford to pay it. So they have to sell that property off to be able to just pay the tax off. And this is what you don't want to do. So if you have planned your things properly, then it is going to help you to avoid paying more than necessary tax, especially so when you have done it and you have lived it, you've outlived it for 7 years. If you prepare a trust and you outlive it for 7 years, then it kicks in. But if you don't live for 7 years, it doesn't kick in. You still have to pay the inheritance tax. This is something that people may not be aware of, that they have to seriously consider. The other thing is you need to protect your partner if you are married or you are in an unmarried relationship. What people do not know is that most of the time, when you are married to somebody and there's a relationship breakdown, where there might be the fact that you are not even living with a person, but you are legally married to that person. if you don't have a will and something happens to you, don't assume that simply because you don't live with a person or because the relationship has broken down, things will be sorted. Everything still goes to that person that you may not be living with for the past year or two or even 10 years. So we've seen situations where somebody might be there, the person would have separated from their partner for so many years, and then all of a sudden he gets a call or she gets a call that because XYZ is no more, you've inherited so much, and you think that those things will be going to your children, but they are not. So the person, the asset goes to the person you did not intend for those assets to go to. It is also important to understand that as soon as you break up, there's a divorce, you need to seriously consider getting a will done, because things may not be as they ought to be. And there are situations where I'm from, if you are listening to me and you're from a different nationality, pardon me, but I'm from Ghana, and we have what we call customary marriage, okay, which allows for polygamy. Even though it might not be lawful here, it is something that still exists in our community. So if you are in a situation like that and you do not have the proper will done, okay, it is possible that whilst you are no more, the assets may go to somebody else that you did not intend to, somebody that probably you did a customary marriage for 10 years ago, 15 years ago, and you did not even register that marriage, and the person will be inheriting your assets simply because that person legally got married earlier than the one who you are legally married here in UK. So these things can create a lot of problems, especially for people who have cultural issues whereby the rules from where they come from and the ones that are here may conflict. So it's very, 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 very important that you get these things sorted. And Lawyer PK, one thing that I always want to talk about for people is the need to appoint a guardian for your child. It may not be an asset that you are leaving for that child, but you need to appoint, if you are not there today or tomorrow, who need to look after that child for you, and you need to appoint that guardian. And it's so, so key. So it is not simply about financial gains. It is not about that, but it's about who will you entrust your children to if you are no more. Sometimes we assume that once we are no more, automatically the children might go to the children, the grandparent, or they might go to a brother or a sister that you have in mind. But you might not be there, and those siblings may be fighting over looking after your children. But deep down, you may have one particular person that you want the children to go to, or you think the children are comfortable with. So appointment of guardians for children is one of the key things that people ought to consider when they haven't made a will, because if something happens, it can cause a lot of problems. Leah PK, I don't know whether you have a few other things that you want to add to what I've
Yeah,
said, or you want to
yeah,
go into further details on the
yeah.
advantages of doing this will for our listeners. Yeah.
Yes. I think as you were saying, I just want to wrap it up with something that's it becomes it will happen. That is, you don't want to bring confusion into the family. Avoid that confusion in the family when you are not there. Because you know what? If you don't say, or if you don't write it on a piece of paper that you want a, you want a particular asset to go to person A, you don't want this particular asset to go to person B, but you want it to go to person C, and you don't write it down. Do you know what you'll be bringing to the family after you are gone? Confusion, because everyone will be thinking that they deserve that particular asset that you left behind. And the funny thing will be that those people who are thinking that they deserve it, practically, practically, they don't deserve it. But by law, they will come and take it from the deserved individual. And it's only because you didn't put things in order through making a will. So if you would want a confusion in your family or in your relationship or whatever you find yourself in after you are gone, then probably you don't consider doing that. But if you want peace to prevail whilst you are no more, then it is advisable you put things on a piece of paper so that everyone will know who needs to get A, who needs to get B. And by law, if it is appointed that you are supposed to be getting A, you are supposed to be getting B, no one can say that it is not. And in fact, as we are even going to go into it, you might even find out that through your will, you are able to give everything to even charity because you think that you don't want that confused family to inherit anything of yours. And it's your will. However, if you don't stipulate that, that charity that you had always had on your heart to donate to them, they might not have it. And you are going to bring confusion in the family. So I think that would be something that I will put at the end of it that if you don't want confusion, you could have been a peaceful person. But if you don't embark or if you don't do this will that we are talking about, unfortunately, you are going to bring confusion in the family. If you don't want that, then you must do a will. Like that,
Yeah.
I know as we were doing the introduction, we were talking about the fact that obviously most of us who will be listening to this program are foreigners. You know, there are people who have traveled and they've come to settle in Europe. Maybe there are people who are listening to us from Spain, Italy, UK, elsewhere. And as we know, when we travel, we try to um, create assets wherever we left off. And even where we are now, we also create assets. But we might end up not staying here till we die. We might even come here, create assets here, and go back and continue to create assets where we came from. We might also be here and still create assets elsewhere. When we are talking about all these things, someone will be scratching their heads that, oh, so the assets that are here in the UK, the assets that are here in Germany, the assets that are here in Italy, how I would want to do this will that Portfolio Solicitors is selling to me. How do I incorporate all these things so that the assets in Ghana, the assets in Nigeria will be catered for, although I'm in the UK? I've gone back to Nigeria, I've gone back to Uganda. The property that I've got here, if I'm taking the advice to make a will, how do I incorporate this? It's very important that we are aware of this because it is happening. And if you're going to delve into it, you will know certain things that you need to be aware of because the confusion aspect of not making a will will even be worse if you made a will and you didn't do it correctly and you meddle it up. It will bring more confusion. We're going to be right back in a minute because we're going to have a quick commercial break. If you go anything to tea or coffee or anything to drink, or you would now join us and you would want to share the video to anyone that you would wish to hear about this particular program, this is opportunity for you to share this video to anyone. Don't go away because we are now going to talk about people in the diaspora, people who live in abroad, who have assets here or in abroad and also have assets elsewhere apart from where they live. How do they incorporate that into their will? How do they deal with that? So we're going to be right back. Don't go away. You are watching You and Your Right, and it's brought to you by Fortua Solicitors. We're going to be right back. welcome back. You're watching You and You're Right. Thanks for sticking by with us. And I hope by this time people are being educated about why you should consider making a will. And it's time to protect your legacy, what you've worked for. So, before we went for that quick commercial break, we were going to deal with some of the assets that you've got here, wherever you are watching us from, whether here in the UK, in America, anywhere in Europe, anywhere on the surface of the earth, the assets that you got there and the assets that you go where you are thinking of going back to. As Daniel said, most of us probably watching us might be from Ghana. So we will use that as an example. You've lived here in the UK, you've got assets here in the UK, you've got some of the assets in Ghana. How do you incorporate that into your will? Is it advisable to have two wills? One where the assets are. For example, you've got an asset in Spain. Do you make a will to cover that asset in Spain? You've got another asset in Morocco. Do you make a will to cover that asset? We're going to talk about all this, and you will know that there are disadvantages and advantages of making foreign wells, making one or two wells if you have a particular estate. And as we always say, this program is just for educational purposes. We also deals with wills and probate. Wills and Probate Department. There are specialist solicitors there, and I'm glad to let you know that Lawyer Daniel is the head of the department when it comes to wills and probate. So if you are thinking of making a will for yourself, or if you know anyone who wants to make a will, they should take our details on the screen. Come and seek professional legal advice after this program. If you want to give us a call to ask any quick question in relation to wills and probates, you just give us a call, and your first initial consultation is going to be free of charge, as we do always. So the question will be, do I need a foreign will if I am here in the UK, or I should just go to a solicitor wherever I am on the surface of the earth and make a particular will and think that it is going to cover all my assets wherever I find myself? There are disadvantages and advantages. One of the things that you need to consider is the laws of the land that the assets are. There are so many jurisdictions when it comes to this particular legal term, meaning every place and their laws. There are certain laws that will prevail in area A and might not prevail in area B. So that is what we term as jurisdiction. So when you are thinking of making a foreign will, as I said, there are advantages and disadvantages. So that means it is not straight. It is not something that we can say, oh no, you have to make one well because you, the testator, all the assets are for you. So if the assets are situated in Ghana, situated in Uganda, and you are here, there is no need because you are the person that is going to distribute that asset. There might be positives there. There might also be negatives there. So you need to look at the laws of the land where the assets are, and also even the laws of the land where you are the testator is, because all these things might have effect. Some of the jurisdictions or some of the countries might have something we call common law jurisdiction. As we said, this is just for educational purposes, so it's not now we are going to go into it. But simply put, there are certain laws that are common law, meaning that most of the Commonwealth countries, they've got certain laws that will prevail here. For example, in the UK, when you go to Ghana, it might prevail there. Some of them too are civil laws. Predominantly, they are in the European states. We also have Sharia law, which we know it is normally in the Islamic state. So probably you've gone to Dubai, you bought a property there in Dubai. The laws of Dubai would have an advantage or disadvantage if you are obviously thinking of making a will. So we need to be aware of that. And we also need to be aware of the inheritance and the trust aspects when it comes to that particular jurisdiction that you find yourself in pertaining to the law, because some of the areas might have inheritance tax dependent on the threshold of the assets that you got. Some also might have trust issues that would be dependent on the laws of that particular land, which you must be aware of. Because if you are not aware of it and you decide to make your will only here in the UK and leave it thinking that because I've made my law here in the UK, it will cover my assets in Uganda, maybe Uganda might not accept or will not have a threshold, for example, an inheritance tax threshold that maybe the UK would have that. And lastly, when I was researching into this and I found this, I was very, very marveled, but not many people will know about it. And it's very interesting that people are aware of, because I know in our community there are so many people who have come from European states that they live here now. Meanwhile, they've got assets back where they came from, Italy, Spain, and other places. There, there is something we call false heirship. That particular law, say for example, here in the UK, I can decide that I would make a law and give all my assets to my friend Daniel, because I think that I want to give it to him. That's all. And as far as it's in my will in the UK, no judge or no court will depart from that, because in the UK we don't have that false headship. But it will interest you that in some of the European countries and some of the other countries in the world, you can decide that you are giving your estate to charity or to a friend who is not a family member of you. In specific countries, they will say no. Your law that you prepared, sorry, your will that you prepared in England that allows you to give every estate that you've acquired to a friend who is not family, to charity who is not family. The property is in Spain, the property is in Italy. We are not going to allow you to take that property or to bequeath that property to your friend, because your friend is not family. You might be aware of this or you might not be aware of this. But if you didn't know the laws of the land and you decide to make that one well, not consulting the laws of that land, that well will be challenged. So it is well and good to make that foreign well, but you need to know the laws of that country, because it will come a long way to make to prevent that confusion that you don't want to create by making that well. Daniel, I, I hope there are more advantages and disadvantages when it comes to thinking of making a foreign will or not. So if you can take us through a few of them, then we will enter into other aspects of the program.
Yeah, thank you very much, Alaya PK. It is true. The decision to make a foreign will or just to make one will based on the country that you are domiciled or based in the country that you live in is a big decision that many people contend with. And as you rightly said, it's got its own advantages and disadvantages, but you have to weigh each one and decide for yourself which one will work for you. As I always say, we solicitors or we lawyers, it is not our job to tell you which option to go for. Our job is to tell you what the option you are choosing, the implications that it means, and then you can make the ultimate decision yourself. So, for instance, the question of whether you want to make a one will that will cover all your assets, or you will make separate wills based on where those assets are based, can be determined on who the executor of the will is going to be. So, for instance, if you live in UK and the executor of your will, when we talk about executor of a will, executor is the person who, when you are no longer around, the person will ensure that your words or what you have written in the will is done to the letter. So that person is in charge of that will. So that executor, where is that person based in? If the person is based in, let's say, your country of birth, and you currently live elsewhere, such as you live in UK, but your executor lives in Ghana, and you are no more, what is the practicality that that person will be able to get a visa, come to the UK, and ensure that the contents of your will is adhered to? That may prove to be a difficulty. So sometimes, look, depending on who the executor may be, you might decide that, you know what, I have one property in my home country, I have another property in the UK. Let me do one will that will cover all my assets in the UK, and then let me get a Ghanaian lawyer or my home country lawyer to do another will which will cover my assets back home. But it also creates that difficulty that when you are not longer around, there might be a conflict of what you have done. Maybe you said something in this will which then covers a property in the other will. So whenever somebody is making a will for you, it's important you let a person know that, look, I have this will concerning these assets. Can you have a look at it, so that they make sure that there's no conflict of those two wills that is being made. And the other thing is, it's also important to consider the how probate is done in each country. So the nature of a probate in UK might be different from your home country. So you need to understand it, where the speed at which it goes, the tax implications that you may pay, and all that. It's something that you need to seriously consider before making a decision on whether you are going to make one will or you are going to make separate wills. But if you ask me personally, I believe the disadvantages of whereby you have delays in administering an estate based on there being one single will is something that need to be seriously considered because of the tax implications that it may amount to. So, for instance, if you have one single will which it's only based in the UK jurisdiction, and you've got assets in your home country, you need to understand that we need to be able to get letters of probate here before it can be taken to your home country to be sealed before they can execute it. All these things are things that you need to seriously consider discussing with your solicitor or your lawyer. And lawyer PK, because time is fast spent, because there are a lot of common mistakes that making a will can also bring up, that we need to take account of. That we, if you permit me, I will quickly state a few of them. If you want me to go ahead, I'll
Definitely.
do so. If you want to add something to do with this foreign wills, please go ahead as well.
No, I think you obviously the fact that probate might be delayed where you live and all the aspects in relation to the estates and everything. Yeah, it's covered. And as we said, if you need further information, you can give us a call. So you can go ahead and point out some of the pitfalls that people need to be aware of. Yes, please, you can go
Yeah.
ahead.
Yeah, when making a will, there might be a situation where people might ask, do I need a solicitor to do a will? Do I go to a supermarket and buy the document, a will, and do it myself? Do I stay in my bedroom and write it on a sheet of paper myself? And these are questions that people will be scratching their head with after tonight. And one of the reasons why you need to be careful whichever option you choose is the fact that you may not be aware of the formal requirements needed to make a will legally valid. For instance, you cannot just be a beneficiary in the will and also be an executor in the will as well, or you are witnessing the issue to do with witnessing of a will, who can be a beneficiary and executor at the same time. These are things that have formal requirements that you need to be aware of. So if you are considering whether I need to do the will myself or give it to somebody, this is something you need to be aware of. And then failing to take account of all the money and property available is a common mistake that many people may make. So imagine you don't have £10,000 in your account, and then in your will you decide to bequeath £20,000 to somebody, even though you don't have the money. How do you deal with that when you are no longer available? So it's important we take into account all the money and assets available when making a will, so that we don't make a mistake. Then failing to take account the possibility that a beneficiary may die before the person making a will. When making a will, you need to think about that as well. So if you say X amount ought to be given to this person, what happens if that person dies before or passes away before you? Or what happens if the two of you pass away the same day? So it's very, very important that when making a will, you make provision for what happens if that person passes away before you, or if the two of you pass away at the same time. So that is something that solicitor may draw your attention to when considering the need to make a will. And then changing the will, if these alterations are not signed and witnessed, they are invalid. So you may make a will when you had one child, and then now you have three children. You may want to change that will. Did you alter it properly? These are very, very, very important things that you need to be aware of. If you don't change it properly, it may cause issues for you in future. And then being unaware of the effect of marriage, registered civil partnership, divorce, or dissolution of a civil partnership on the will. It's very, very important as we talk about that whenever these major events happen in a person's life, it may have an effect on your will, and you need to consider it. So, if you are married, if you've dissolved it, if you are separated, or whatever, it's important you look at it again, or you look at your will again. What people need to know is that will is a living document. Will is not something that you just do and you put underneath your bed and go away and sleep. Will is something that you may have to seriously consider looking at as time goes on, as your life issues in your life changes. Then being unaware of the rules which exist to enable dependents to claim from a state if they believe they are not adequately provided for. Lawyer PK, this is so crucial and very, very important. There may be somebody who may have helped look after you in your old age, and the person may have helped you, cared for you, expecting that when you pass away, you will bequeath something for him or her to buy something with, and then you pass away and you don't leave anything to the person. And these are people who can come up and challenge the validity of a will. So you need to be aware of the rules which exist to enable those people to bring a claim against your assets or your estate. What I tell people is that sometimes you may have a family member that you are so embittered against that you don't want to leave anything for that person, for one reason or the other. Sometimes it may be beneficial to leave a token to that person than not to leave anything at all, because you not leaving anything at all might make that person to bring a claim against that will that you have left behind. So we will tell you that, okay, this person has been very, very difficult in your life. Leave a Bible for the person, leave a Quran for the person, leave a tenner or leave £20 to that person. It is better than leaving nothing to that person, because you leaving nothing to that person means he's got reason to bring a claim against that estate of yours that you've left. And this is particularly so because it's going to delay everything. It's going to cause a loss of misery, and it's going to cause a lot of hardship for the people that you've left behind. And that's the last thing that you will need to think about. And for me, when people are thinking of what they need to do, whether they are supposed to do it themselves or use a solicitor to do it, there may be certain factors that will determine that as well. Whether you've got a business, whether you've got assets abroad, whether you've got children, you've been married, you've been divorced. These are things that you need to seriously consider when you are making a decision whether to go to a supermarket to buy a will yourself, or to write it on a paper at home, or to consult a solicitor, because those things may make the will that you are doing complex. If you've been married and divorced, come on, make sure you consult somebody. If you've got children out of wedlock, very important. Make sure you consult somebody so that you can take care of those children who were born out of wedlock. Very, 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 very important. And whether you have a permanent home in UK or abroad, or you are resident overseas, you've lived overseas before, you've got business abroad before. All these things are factors that need to be considered when making a decision whether you are going to make a will yourself or you are going to give it to a solicitor to decide on it. Lawyer PK, I think we are almost getting to the
Yeah,
time that we need to be finishing. Do you want to wrap
yeah.
up for us before we go away?
Yeah, as you are talking about this challenging of the well that you've gone to WA Smith to buy, or you sat down
I wouldn't
and
mention
you
WA Smith.
drafted.
It could be any supermarket, Lawyer PK.
No, no, you don't advert for them. It's true, I'm sorry. But basically, what I'm trying to say is that if you go to a supermarket and you get that well, and in fact, is it true that even the way uh, the the well is stapled and unstapled can even bring a challenge to the well that you prepare? Am I right in saying that?
Oh, yes, yes, that is very true. I mean,
Yeah,
you may have
yeah,
stapled the will that you bought from the supermarket after you've done it, and then it has become necessary for you to scan it and save it in a digital world. You want to save it somewhere on your cloud or your hard drive. So you unstaple it and then you scan it. And simply that act alone can invalidate the
yes.
will that you have done. So these are some of the things that people need to be aware of. And you can also make the will, keep it underneath your bed, and you've decided that one particular dependent of yours you have not catered for that person in the will. The person comes, sees it, and sees the name is not there, and decide to rip it into two. You haven't kept it anyway. So there are so many things that people need to think about when talking about wills and where to do it for and all that. So yeah, Lea Piki, your point is very valid and it's important people consider that.
Okay, thank you very much, and thanks to everyone who is watched us this program. I know that people are educated because, as we said in the beginning of the program, it's a topic that people don't want to talk about, but it's inevitable. But I know that people will sleep tonight or be thinking about it wherever you are watching us from, and you might seriously consider consulting a lawyer to draft that legal document for you that we call a will, so that if you are no more, then your the people that you would want to name will get what they deserve. As we always say, this is just educational program. Don't take it as legal advice, but if you want proper legal advice, you can consult Photo Solicitors. Our telephone numbers, all our details are on the screen. Consult us. Take advantage of the free initial consultation. You don't even know how much it will even cost you if you want to make this well. Thanks for watching, and thank you, Lawyer Daniel, for joining me this evening to discuss this program, this particular topic on this program. And I know that viewers are well educated. Thank you very much. Thanks to all those who shared our videos. Thanks to those who listen to us. Thank you to our producer for producing the program for us, and all everyone who is part of this program. And as we always say, every Monday from 7 p.m. to 8 p.m. UK time, make time to watch you and your rights. Thanks for watching.